referring to case number 2024-944-0788. The property tract is unsafe. Initial inspection was performed 11 September 2024. Total number of inspections is 6. Total violations is also 6. 0 complied. Date certified letter sent for October 2024. Notice of hearing was 6 July 2026. Posted at property 7 July 2026. Date of last inspection was 14 July 2026. The last hearing was deferred, so this is the initial. There's no active permits, and recommendation is order to correct. Oh. That is the property sign. It is for them. The interior is pretty much gutted. There's nothing in there. That's from the outside. Those are cases.
Do you know, was it a fire or something?
Senior Officer Ruiz, the initial violations we're going to say stems from a flood that caused severe mold and mildew and involved in drivewall repairs. That was in 2024. And there's been no attempt to repair the damage since there's been no applications for permits and hasn't been a proper language for that.
So, Mr. Magistrate, do you want to disclose that as an attorney for the city, I previously litigated against Miramar? That litigation has now resolved, but if you feel that in any way biases me, I'm happy to discuss this position.
I think I'm fine. I too also have testified against Miramar.
All right, what's going on with this property?
For starters, maybe to clear this, I have a copy of the words correct. So I believe maybe this isn't the first hearing, but I do have a copy of the word correct from the previous hearing. Maybe one
So we were here last month, but then it wasn't properly noticed, right? Because I think there was some email.
It was deferred last time because I was told it was withdrawn, but the order to correct I have is dated.
But September 17th, 2025, right? I have it.
Yes.
So is this the initial hearing?
The previous hearing was deferred. I was not the officer that presented that portion of it. My understanding to this point is that we are active request for the correct. We don't have findings scheduled that you need a moment to verify that.
So I think last month it was deferred, but it looks like a year ago, last September in 2025, there was an order to correct. Sure. It was a 90-day hearing.
After reviewing that case, so that was an order to correct issued last year, so it's in position and we can request a daily fine. So that zero activity.
Mr. Magistrate.
I've got some paperwork I'd like to go through with you, if that's okay. I've got a table of contents in the first 3 pages and occupation versus listed. I highlighted that paperwork with them. I didn't have it, they were being invited, and I apologize for that.
Do you have a copy of the city?
I have an extra copy, however, my understanding of chapter 91 is that the formal rules of judicial law doesn't apply here. I can give them to them digitally, or I can hand them a paper copy if that's your preference.
So, I mean, in general, it just helps if we're all on the same page. So if we're going to be reading the documents, if they don't have them and they can't see them, I don't know how much progress we're going to make. Just so,
Sure.
I mean, feel free to go
So
forward.
all of these documents were documents that I eventually was able to attain from the city.
So these all came from the city with the exception of the table of contents, including the order to correct that I have for September 9th.
And so just be aware that we are recording these hearings so that when you step away from the microphone, it doesn't pick it up. So
Yes,
you
ma'am.
just wait till you're at the microphone to speak so that we make sure you can. So what I understood is that you received all of the documents that you just given me, you received them from the city, which I appreciate, but I don't know that it was these humans who were standing next to you would have given you those documents and would know documents you're referring to.
I'd like to go over the timeline, if that's okay with you. Starting with the first few pages I have are public records requests. One submitted on July 2nd, and one
So
submitted.
before we do that, can you just give me a big picture, like what, are you, is your position that this work doesn't need to be done, or like, what's the big
I
picture?
have several positions. One is that I've repeatedly asked for information on the case, and I have a new email from the supervisor saying that there's no cases scheduled for a hearing. I've asked for case details from the officer who inspected it. He didn't respond to my emails. I have two public records that were fulfilled, one by both by MCCD recently, saying there's no city list of all active cases, which was what my PRR was, and there's no, this case wasn't listed on any of those. But there's also other things I would like to talk about, including improper notice, not serving the proper owner, not using the correct placards, using the incorrect ordinances. So my position is that this gets tossed out based on several issues, including the refusal for the city to make contact. I believe in the last hearing, we had an employee of the city say that they were told not to share information with me, and I have new emails saying that they refuse to share information with me. I'd like to go through all of that because it's very hard for me to help this owner comply when the city is actively refusing to give me any information on their case or what to pass along to the owner. That's what I would like to go through.
So
I
my
think it's,
question though is, what is the status of these repairs?
well, for starters, it has been completely vetted, first off. Second of all, it's not, it shouldn't be condemned as unsafe. It wasn't properly served notice. Notice wasn't sent to the proper owner. I read all that documentation with me, so it should be tossed out on the fact that there was no proper notice. It didn't reach the owner, the right ordinance
What
was
is the,
used.
Mr. Register, what is the plan for getting this unit corrected and fixed and running?
It's a concrete building that had some drywall falling because of, it was wet. The officer condemned it as unsafe with the comments of, I smell gray water, but I'm not going inside. And then they used the wrong placards to post the property. They didn't send the notice to the correct owner. They didn't identify the correct unit.
I understand that you have many procedural arguments and we will go to those.
Okay.
What I want to know is, if this unit was flooded in 2024,
It-
and it's now 2026, what are the plans for repairing this unit?
It wasn't flooded, a unit above it was. It's concrete, all the drywall's done, it's not, has concrete walls, so nothing's in danger or unsafe. We can't do anything with it because it's condemned. The previous ownership didn't know what to do with it, they didn't know how to obtain access passes. I've been unsuccessful in getting information from them in the city. So right now, it's concrete walls. The plan for the owner is because there's other units that need work. I don't mean this in any harsh way. Miramar needs a lot of work, and so do their other properties. They want to use this as a storage unit, which is, it's just an enclosed concrete room that they can use as a storage unit. It doesn't have to be habitable. They're not mandated to keep this as a habitable structure. It had some falling drywall that's been resolved. Now they want to use it as storage to put in refrigerators, windows, and stuff they use to correct the rest of the property.
So is it your position that Miramar is not going to be doing any further repairs to this unit and it's going to be as is?
Not permanently, but they're trying to prioritize the money that they have available to try to fix the other issues. They've got to comply with the COA requirements, they've got to comply with other securing. There's a lot to do there, and the properties, believe me, I don't want to be here defending them either, but I also want things to be done correctly, and for us to not go in and focus on this unit when there's other units, other occupied units, other ACs that need to be updated, on top of the fact that there's procedurally, if it wasn't done, it doesn't meet the requirements of the Florida statutes, nor the ordinances for it to be cited.
Officer Reese, what is the city's position if this is used as a storage unit? I just have a question.
From previous cases where we've had structures that were severely damaged by roof collapses, where the owner wanted to change the use of the structure, that required the usage deviation for from the code department. In this case, they never applied for a building permit to do anything with this unit. They never applied for, you have to have permits to do drywall, you have to have permits to do the electrical. None of that's ever been applied for. So they haven't even attempted to correct the violation. If they wanted to gut this unit down to bare walls and turn it into a storage unit, yes, they could, but they haven't even started that process to do it. They They still need the permits to do that work. They haven't done that.
So, Mr. Magistrate, tell me all of the things the city did.
Sure, and for starters, to repeat, we have vetted it, and I believe one of the things that showed in the photographs was that there was falling drywall, which we went in and removed, you don't need a permit just to remove the drywall. There's been no electrical touch, no plumbing touch, and it's not required to be used in a storage facility. There's no change in use. Multifamily uses are allowed to have storage units and storage facilities within their multifamily
Understood.
uses.
Tell me the procedural defects.
Okay, so the first two that I was starting on was that I didn't get any responses on active cases for the property. The next,
That to me is not a procedural defect, that's a communication issue. You're telling me.
which is also problematic if I can't get
Please
information.
don't interrupt me when I'm speaking, no one else speaks. I'm done speaking, you're welcome to speak.
Yes, ma'am.
A communication issue to me is not a procedural defect. I understood you saying that there were defects in the notices and the citations that were issued.
Yes.
Please tell me what those are.
So we don't want to talk about any of the communication issues or the city refusing to share information with me.
How many more cases do we have left to policy? So I have 4 other homeowners who are patiently waiting for their case. Why don't we let them go, and then we can stay here as long as you would like, and you can tell me all the things that are wrong with this case, but I don't want to continue to make this people. So we will put this case on hold. Let's call the next case and we'll come back to this.
Now calling item letter 827, MCE case number 250257.
With all due respect, can I really say all the things or do I need to bypass them?
Tell me what your original.
One small observation might help. So, the city's position is not now, as even Mr. Register would think he was only going to be in one for a matter of months, so that a lot of that's him looking back. So, the order to correct was placed in September of 2025. The 90-day order to correct expired in December of 2025, where the property was found to still be in violation. At the hearing, the order to correct hearing in 2025, Miramar had a representative right here in this room. Her name was Brooke Heath. So the whole we didn't know, we didn't understand the violations kind of goes out the door because they had 90 days to contest any of that. They never did. We verified all of the legal notices were sent to Miramar. They knew in writing from the very beginning of October when the property was cited in 24. At no point did anyone say we had any issues with notification, even at the hearing. They never said we had a problem with notification, we didn't have a problem with violations cited. The comments put in by the original inspector said a smell of sewer gas, that's why he didn't want to enter the units. Did not say gray water, I'm not entering the unit. Those are in his notes. Now, those notes are internal, they're not part of the official documents, but so we're asking that you consider everything prior to 2026, because everything since it's after the order to correct has already expired, they were already in violation.
Thank you. Tell me what you would like me to do.
With all due respect to the officers and everybody, most people don't have the same experience with some internal workings with the city and the knowledge of the ordinance codes, so it may not be as clear to someone else as it is to me when there's something that's not done right procedurally or something that's violated. So for starters, and it's in the packet, you're welcome to look at it. I've asked for agenda copies, and you can add one more to it, because I noticed that today's agenda says, please contact MCEB if you would like a copy of the agenda. She's got mine. So the website, the pages all say, please contact us for a copy of the agenda, because I had a problem getting notice of the hearings, which is what the issue was last time.
Okay, so help me, I have a pile of papers here in front of me.
For me, it's problematic that I can't get information to know what's scheduled. I can't get a case recap to know what's scheduled. I realize that they're sending information to Texas, but I'm trying to do what I can to make them compliant.
Is there a document?
And I know that there's no other citizens in the room at this moment, but if someone doesn't know what they're supposed to be doing, it's going to affect them a lot differently than it affects me. This property's not mine. Yes, ma'am.
I want to focus on procedural posture of this case. So you're telling me that you have been requesting information about when hearings are being held on this particular unit, right?
Correct.
Okay. Is there a document in front of me that represents that?
Yes.
Which doc? Tell me which one I should.
There are public records requests for the responses. There's cases. I've done an email again to the municipal code enforcement.
You have kindly labeled these with letters and numbers. Can you tell me which one of these?
Sure. Page 6, 7, 8, and 9 are me requesting the agenda notice so that I know what I need to prepare for.
Okay, 6. So, as I look at these, like the tab is 6, 7, 8, 9. So am I looking at 2, 6?
No, so on the table of contents, there's a Roman numeral section. And so for those sections, I put a Roman numeral up top and the page number right below it. I don't have my copy, but I'll borrow Randall's since he's so kind.
Okay, so I'm looking at tab 1, Roman numeral 1, and you said page 6 and 7?
6, 7, 8, and 9.
So it only goes up to page 5.
May I come up and look at your packet? And the rest of you. So this one's page 6. It's got the page number at the bottom, and it's section 2, page 6.
Yeah, I thought we were on section 1.
We discussed section 1 earlier, and you asked me to skip to the emails that show that I requested information and it was not given to me.
Okay, so what is in section 1?
Section 1 is me putting in 2 public records requests, and when they were fulfilled, I was sent a list of what was supposed to be all active cases in the city of Jacksonville, and none of them included the properties in the hearing. So if I were a different citizen, I would assume.
You're not a different citizen, we're just talking about this case. So you did a public records request asking for every active case in the city of
Correct,
Jacksonville.
and there's 3 emails in the first 5 pages from the city saying, here's your request, you're requesting all active cases, here's your results for all active cases, and then the third one from MCCD on the second public records request saying, here is your all active cases.
Okay, so connect the dots for me. How does that affect this hearing?
I've got more to go through, but that's telling me there's no active cases to move forward for a hearing, to not prepare for you. I asked the officer to send me the case recap and information. I get 0 response. I asked Supervisor Batach to please let me know, because we have a code card with no case number saying you're going to code board, and the response is that you have no upcoming code board cases. That email is on page, that's on page 21 and 22, and its code card is on page 23. And if with all due respect, you had opportunity to speak.
So everybody's gonna have a turn. So just, okay. So Mr. Rocha, I'm trying to understand didn't your client get, you or your honor get notice of this hearing today?
I assume that there's notices going to Texas. He forwarded me the cover sheet of you've got a hearing, and that's all he forwarded me, and I said, can you please send me the case recap and the violation notice? No response. The other problem is,
But,
may I please?
no, I get to stop. But by law, they have to notice the entities that are on the property appraiser's website. And if you are not listed on the property appraiser's website, then you wouldn't be getting notice. So how is that a problem?
Correct, that would be the topic of why can't the city just work with citizens to correct? But further down in my documents, I also have the deed from the property appraiser saying that this is a Delaware corporation with a Delaware representative, and they've never been noticed for the initial, they've never Starting on page 62 are the ordinance sections. Between pages 40 and 43 are the deed printed out from the property appraiser's website.
Let's do one at a time. Okay, so I'm on page 62. Let's see, so I'm on 518.302, notice to owner. We shall serve notice of such finding on the owner. So what are you saying, that there's a deed from when?
The property appraisers, the most recent deed with the property appraiser says it's owned by Miramar Albatic LLC, a Delaware corporation. The Delaware corporation is a completely separate mailing address and registered agent, and no notice ever went to them. This ordinance says that you have to notify them.
Why would it need to go to Delaware if it's going to Miramar?
Because the Delaware LLC is the owner of the property. The deed is recorded under the Delaware LLC. They looked at the deed and pulled up the Florida LLC and didn't send any notice to what's actually recorded on the sale, which is the Delaware LLC.
Okay, I'm not trying to be flip, but why does that matter? But your client did actually get notice.
Because the ordinance requires that you send it to the proper owners, and they didn't.
And what's the remedy if the ordinance is not compliant?
We haven't even gotten to the fact that they didn't cite it for the correct ordinances.
I'm just saying, what's the remedy if the entity that you think needs to be noticed didn't receive notice, but the entity that needs to be here got notice?
If you go back to page 27, my apologies, 24, Supervisor Batachka follows procedure on a different case for the same property, saying, we didn't use the correct building number, we have to start this case over to make sure that we serve proper notice. The unsafe case was active at that time, and they didn't.
So there's a difference between actual and constructive notice, is what we're talking about.
Can you repeat that again?
There's a difference between actual and constructive notice. Do you
Okay.
agree with me on that?
Okay.
Okay, are you saying that your client, I shouldn't say your client, are you saying that Miramar did not have notice of this hearing today?
I don't know what they received. I only know because he sent me an email, I responded back, he didn't
You
respond.
are here on behalf of Miramar. So clearly Miramar knew that you.
Nobody remarked on
Please
this.
don't interrupt me.
Sorry.
I mean, let's look at the file. So there was a notice of hearing, correct?
It was a notice of hearing. It was sent to the LLC in Texas. It contained the wrong building number, as did all of the other notices that went out. The order to correct had the wrong building number. The notice of violation had the wrong building number. Officer Weiss put in the comments 2 months ago, this is the wrong building number. A year and a half ago, Supervisor Batachka found that the wrong building number was listed on another case for the same exact unit, and they did what was procedurally accurate to send out the notice saying that this building, this specific building is in violation.
Wait, so when you're talking about building number, are you talking about the address where the notice was sent, or the building number that's in violation?
I switched to the notice and the unit, the building number not being correct.
Okay,
It had the
I
wrong
thought we were
building.
talking about notice, and so I'm looking at the property appraiser's printout, and it says that the owner of the property is, it's at 2424 Ridge Road, Rockwell, Texas, 75087. And that's the address that the notice of hearing went to. So how is that notice effective?
I'm looking at the deed that was recorded. I don't know that the property appraiser made an error or not, but I do know that the ordinance says that they're supposed to notify all owners, and I would think that would start with the owner that's listed in the deed.
Okay, so who's the owner of the property? Where's the deed?
It's on page 64, 65, and 66. It's the deed that's recorded in the property appraiser, the most recent deed, and then 65 and 66 are the looked up from Delaware, showing the registered agent. And the address.
64 is the printout from the property appraiser. I don't see a deed. I just see the 3-page printout from the property appraiser.
Initially, my apologies, I didn't have a PowerPoint initially, I planned to go in order, and I would explain this as I go, so if you wouldn't mind giving me a
Delaware corporation doesn't mean it's located in Delaware.
Okay.
No notice had to go to Delaware.
Okay.
What's next?
All of those have the correct building number on them.
Okay, what is the correct building number?
Randall, can you help me out? Was your comment on it in March?
So, yes, I'm sorry, and so, Mr. Register, here, we are Mr. Register, we are Officer Weiss, we are Magistrate, we do not use first names, this is the court proceedings. What is the correct building number?
So the correct building number is 5642. The section of our system, the fixed system that we use, only allows for so much character to be put in. The clerks entered in that information because it's 3102 is the parcel ID, and then each building has their own address, which is a 4-digit number, and then the unit number. When the clerks entered in that, the last digit did not make it in there. The address is 5642. That was updated in our comments when we started doing the inspection, so we would know to go to the correct address. But us at the officer level will have to change the template part of that case. So all of the notices had the information that was put in there. We just don't know where to change it.
So, Mr.
Except that we
Register,
do have a way to change that because Rob changed it on another one, and that's on page 24,
Mr.
where
Register,
they changed the building.
Mr. Register, does Miramar on at 3102 Tall Pine Lane, is there a building there? Do they have a building in 564?
There's 48 buildings on that property.
Okay, are any of them numbered 564?
There's no.
How many of them begin with 564?
I'm not certain.
Okay.
There's 48 buildings. I don't know how many of them are.
So do I understand your argument correctly then, that because it says 564 and not 564-2, that Miramar did not have proper notice of the street?
My argument is that the ordinances that require notice were followed. That's my argument.
Because it says 564 instead of 564-2?
Yes, because they didn't specifically notify the location of the building that's supposed to be notified.
Okay, I disagree with you on that. What's
Okay.
next?
So all of the violations that were cited on it were under unsafe violations, such as they need a building permit, they need a plumbing permit, all cited under part 3.
Part 3 of what?
518, 301, using the definitions.
Tell me again, there's 518 and material limitation.
I put the definitions of 518.11 in there with the definitions of unsafe. I don't know if I put 518.301 in there. But typically, my experience with the magistrate office is we have those ordinances available.
So is your position that they cited the incorrect portion of the ordinance?
On top of citing the wrong ordinances, they use the wrong notices. The notice under chapter 518, part 3, says that they have to use specific language when they condemn a structure as unsafe. They didn't use the placard, they used that specific language. It's in the documents they use. I provided all of the pictures of all the placards they posted. They all posted placards that are required for vacating occupied unit that is not unsafe, it's unfit for habitation under part 4 of 518, but they said it's unsafe, and the requirements of that has specific language. It's supposed to be on that placard. It says condemned, your notice to this, the picture starting on page 44, and the placards, these are their pictures, not my pictures.
Okay, I need the language of the ordinance code that dictates what should be in this document.
Page 60 and 61 are the placards. Page 63, 62, my apologies, shows what the form of notice is for all of chapter 518. It also does this 518.301, which says when how to deem a property of a building is unsafe. And then it has 518.302, which talks about the notice shall be written and shall include the street address of the unsafe structure and the legal description, a description of the building that's deemed unsafe, and a notice containing as a minimum the following displayed upon the premises which it relates, and then it quotes, condemned, this building or structure is unsafe and subject to demolition, blah, 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 blah. That's highlighted with red text, and the very next page shows the two different placards, the top one being the one that has that language for unsafe structures, part 3, the second placard below it being the one that they use, which is the one that is typically used to vacate a structure that's unfit for human habitation, to tell people they need to leave. And in the language of that section, it says, for those properties that are not unsafe structure, not yet in a condition where they can be unsafe. I do have those ordinances, I didn't. This first page is what I put in part 3.
Okay, but that's the same as that, is that the same as what we already?
That's the one I already gave you. These two are the ones from part 4 about unfit for habitation, and the notices and appeal process for those, which is the notice that they use to condemn the property.
Can I just interrupt you? So these ones that you've given me are blank. Are you saying that these are the ones that were posted in the property?
Those are the examples of the actual proofs the city used. Those are what the placards look like. The
Okay,
pictures,
where are the pictures of what was actually posted in the property?
their pictures are on page 45, 46, 47, 50, 53, 54, and 57.
Okay, so what is significant about the difference between the language and the two placards? Why does it matter if they use one that doesn't? I don't understand why this is significant.
Because the ordinance says if you condemn a structure as unsafe, you must have this language at a minimum, and they didn't provide that language.
So there's a lot of laws out there that say you have to do things or you don't have, or you can't do certain things, but not all of them provide a remedy. Meaning that if you don't comply with that, nothing happens. What's the remedy here? Like, where in the ordinance does it say that if you use the wrong placard, then this is what happens?
I'm not sure where that says what happens if you use the wrong placard, you use the wrong ordinance, you don't send out the right building location required by the ordinance, you don't mail it to all of the owners as it says in the ordinance. I don't know what the remedy is for that, other than proper notice wasn't served. If they didn't properly follow the proper guidelines of the ordinance or follow the Florida statutes, the case is wrong. We shouldn't be here. They tell me when I ask about the case status updates and hearings that you have no cases coming up. All of that is wrong. All that's problematic. And with all due respect, if it weren't me, I don't think that I would be getting the same pushback today when there's this many errors.
But what I want to know is what is the legal significance of those errors? How does that get you what you want? Things can be wrong, doesn't mean you have a remedy. So what I need to know is where does it say that the remedy is that they can't cite Miramar for a violation of not repairing the structure?
Where does it say that they can cite for a violation and use the wrong notice, the wrong placard, and not follow the guidelines to cite a property?
I don't have to prove anything.
No, the burden's on the city to prove it. That's in chapter 91, and I've got that too.
Right, but
They are,
I have not heard you tell me anything that even if they're using the wrong placards, that means they cannot bring this case against Miramar. Where's the authority for that?
the authority that they're supposed to follow what the ordinances say, what the Florida statutes say. I would imagine it's in the Florida statutes 162 part 1, and chapter 91, chapter 518.
Do you have something that tells me that when you use the wrong placard in your condemned structure, that the case?
No, I didn't. I wasn't expecting to bring any case law with me because chapter 91 says that we don't have to follow former case law. I'm here to say all these errors exist. The proper procedures weren't followed. The city's not giving me any information to try to make these corrections. I'm hoping that you recognize this and acknowledge that it's a little bit problematic that they can get away with this many failures. If this was some guy who can't afford to make these fixes
Mr.
by
Register,
himself.
again, we're not talking about other people, we're talking about this case. I want to know what procedural defect did it create in this case that
The
the wrong,
defect-
please let me finish. What procedural defect did it create in this case that, if what you say is true, that they used the wrong placard to condemn the structure, somehow prohibits them from pursuing this case?
They didn't provide proper notice. They didn't
So you keep saying that, I mean, there's two issues that I've already ruled on. I've already said, yes, that it's not improper notice because there was one digit left off of the building. And I said it's not improper notice that they didn't send notice to some Delaware address. So if those, are there other issues that you have with proper notice?
They didn't use the right building number. They didn't use the right placards.
Right.
Yes.
And I've already had ruled on.
They comment that Randall couldn't figure out how to read.
Then Mr. Reese, Mr. Reese, we're not gonna make disparaging comments about you.
You know? Yes, ma'am. Property has a unit that is uninhabitable due to mold, mildew, and strong odor, all sewer gases. Uninhabitable due to mold, mildew, strong odor of sewer gas emanating from the interior, gray water on the interior and exterior. Ceilings can be observed falling. Due to strong fumes, did not enter to inspect further structure damage. Did not enter to inspect further structure damage. Ma'am.
What's the significance of that? I don't understand what I agree with.
I feel like I've pointed out enough issues with how they're citing this, and I do respect you so much. So at this point, if you believe that everything's fine, then I'm at mercy of what you've ordered, and I'll have to talk to the team about what they want to do with that order.
So, getting back to your argument that you believe that the marijuana is not cited under the correct provision of the ordinance code, is that one of your arguments?
That is one of my arguments, yes.
Okay, so what provision should they have been cited?
For starters, there was nobody living there, so there's nobody there to kick out. They could have cited for the falling drywall, which was falling because of the water damage, which was already removed over a year ago. It's just concrete walls right now. That's not a violation for an empty unit to have concrete walls.
Okay, so I'm having trouble understanding, so help me understand, so what provision of the code was Miramar cited for? Was it in 518?
518, 301, for the definitions in 518, 111.
Okay, and I have that. Can you remind me where in the packet that is? Is that 62?
Page 58 lists the ordinance sections that they used.
Okay. So this is, page 58 is a case recap. So these are all citations under 518.111 and .301. Is that correct?
That's correct.
Okay, and so is it your position that, I guess, help me understand, like, what's wrong with these citations?
There's no evidence that there's a violation of any public code. There's nothing documented that there's a violation of public code. There's no documentation that it's damaged to the extent that it's dangerous to the health and safety of occupants or the public. One, it wasn't even occupied. The structure was standing vacant and open. They served that notice. They corrected the address in that one. They secured that property as parts in danger of being falling, but it's not. It's concrete walls. It's a violation of the property safety and maintenance code in general, but under an unsafe ordinance, and structure is a violation of the building code. And I'm not certain what building code they're referring to. There's been no electrical safety inspection. There's been no observed water piping down. twice used the word fire, but there's been no fires on that.
Officer Reese, do you have a response to that?
Yes, ma'am. The city's position is simple. We've already brought the case in 2025 with evidence that we had to make this an unsafe case. We got an order to correct it, granted by this board. When we went back to do that board ordered inspection, the property was not in compliance. The city wants it in compliance because they just failed to bring it into compliance. That's our position.
And so, is it your position also that the provisions of the ordinance code that were cited on this page 58, the case recap, was printed May 28th, 2026, that these are these violations accurate?
Good morning, my name is Robert Koch, supervisor for the city of Jacksonville, Florida. One of the violations says structure damage or deteriorate to the extent it's dangerous to the health and safety of the occupants or the public. That was cited because of all the drywall that was falling from the ceiling. You can see in the pictures of the initial inspection that the drywall was literally falling from the ceiling.
Okay, let me pause right there. So, Mr. Register, why is that not, what's wrong with that violation?
It was structurally unsafe, it was not provided, there was no threat to the public. It had some water damage because the drywall was hanging, a piece of drywall was taken down. That's not something that you can condemn a structure as unsafe for.
Okay, so your contention is just it's not true.
Correct?
Okay, but is there a procedural defect with what provision of the ordinance code that you've chosen to cite?
Yes. They didn't use the proper notification. They didn't use the language that you would use for condemned structures in the
Time
proper.
that just gets noticed. Just in here, when they chose to cite Miramar under 518.111.301. Doesn't the city get to decide what they want to vote to violate?
Yes, they can change the legislation and change the notice, was it 302? But under 302, which the city voted on, it says at a minimum, if the chief condemns a structure as unsafe, they must provide this specific language, which is on a different platter. It wasn't on this one.
I think we're on the same page. My question is, if the city believes that Miramar was violating the ordinance code under 518.111.301, and that's what it was cited for, what's improper?
They didn't provide the proper notice.
And what notice was that? Are we back to the Delaware address and?
No, we're not. I'm trying not to jump around with the different questions. We're under part 302, notice to owner. It says at a minimum, if they determine it to be unsafe, they must use a specific notice. If they determined that someone had a broken window that is a violation of 518.419 and turned around and condemned it as unsafe under part 3 and wrote a citation under part 2, all of that would be, it's not meeting the requirements of the code. They didn't meet the requirements of the code on multiple things here. That's my issue with it.
Officers, Marshall, I interrupted you. Did you want to continue?
Just in the notice that was sent on October 3rd, 2024, it says the notice was sent to Miramar residents, Tick 1, Tick 2, Tick 3 LLC. The actual notice states pursuant to Chapter 518 of the Jacksonville Property Safety Maintenance Code, reference property is condemned as an unsafe structure, and inspection revealed the following list of items which are going to Mr. Register cover. It says the property must be kept safe and secure against unauthorized entry, cannot be reoccupied until it has been re-inspected and complies with all requirements of Chapter 518. The further goes to state the structure may be demolished or otherwise the structure may be demolished or otherwise be made safe by the city without further notice. The unsafe conditions are not corrected within 30 days from the date of this notice. So that in the event the unsafe structure is not demolished or repair work is not performed within the time as required by the Chief Municipal Code Compliance Division or Building Codes Adjustment Board, this shall cause continued investigational inspections. It could result in demolitions or repair work or other work to be performed by independent contractors, city employees,